Hi, my name is Chad Biggerstaff. I'm an attorney with Ramos Law. Welcome to another episode of The House of Law. Today we're going to talk briefly about ski liability in Colorado. Stay tuned. Skiing in Colorado is an extremely popular sport. Hundreds of thousands of us head to the slopes every year. Have you ever thought about the rules that govern the ski area operators, or you as a skier or snowboarder? Under the Colorado Ski Safety Act, which can be found in the Colorado Revised Statutes 33-44-101 et al., ski liability cases fall into one of two categories: cases against the ski area operator and cases against other skiers or snowboarders. Ski area operators is basically the resort which you're skiing at. They have a statutory obligation to advise you of the inherent risks of skiing or snowboarding. Have you ever looked at the back of your lift ticket? On the back of the lift ticket is a statutory requirement or notice from the ski area operator that they're required to disclose to you. It reads, under Colorado law, a skier assumes the risk of any injury to person or property resulting from any of the inherent dangers and risks of skiing and may not recover from any ski area operator for any injury resulting from any of the inherent dangers and risks of skiing, including changing weather conditions, existing and changing snow conditions, bare spots, trees, stumps, collisions with natural objects, man-made objects, or other skiers, variations in terrain, and the failure of skiers to ski within their own abilities. Since this is a statutory requirement of the ski area operators to disclose this to you, by putting it on the back of the lift ticket that's attached to you while you're skiing, it's difficult for you to make an argument that you were not put on notice or unaware of this requirement. This notice helps protect the ski areas against lawsuits for injuries that occur on the slopes. As for us as skiers and snowboarders and all the others that are on the slopes with us, we too have obligations to each other while we're skiing. In Colorado, as in most states, a skier-to-skier collision is not an inherent risk, nor is it a risk that's assumed by anybody on the mountain in a suit by a skier against another. As stated in Colorado Revised Statutes 33-44-109, each skier has a duty to maintain control of their speed and course while skiing, as well as be aware of all surroundings and objects below them to avoid any collisions. The obligation is on the downhill skier to avoid these collisions. As a skier or snowboarder, another thing to keep in mind is that although alcohol is served on the slopes and marijuana is legal in Colorado, skiing or boarding while impaired from either of these two substances could open up a cause of action for punitive damages. Punitive damages are an additional penalty that if you are responsible for the injury of another, you may not only be responsible to pay the expenses of the medical treatment for that injured party, but you may also be obligated to pay punitive damages due to your impairment. This is just a couple of the rules that apply to both ski area operators and skiers on the slopes. Be aware of the rules, and they may change depending on which state you're in or what resort you're at. So be aware and have a good time out there. That's it for today. Thanks for joining us. We look forward to seeing you again on another episode of The House of Law.